We are going to start our first lecture with the introduction to mercantile law. This will be just an introduction and I have split it conceptual wise. So it becomes easy for you to understand. First concept, that is C1, will be meaning, object and branches of law. C2 will be meaning and definitions of the term mercantile law. And C3 will be sources and scope of mercantile law. So friends, when it is given as conceptual, it becomes easy for you to understand. And when you are writing the paper also, it will be very easy. Now first we must know why we are studying law. So in everyday's world, when we see maybe for the society or for the business, without the existence of law, it will be very difficult because the people will not care for others. As we have the right of freedom, everybody will do according to their own wish. Nobody will care for others. And there the importance of law comes into existence. Now, in a civilized society, every person is expected to know law and observe that set of rules which governs human conduct and behavior. Now, first we start with, in our India, who makes the laws? You must know that in a country like India, which is a democratic country, the parliament or the appropriate state legislature makes the laws. And then they are enforced by the state through its courts. So this is the procedure we observe in India. Now, we start with the definition, that is our C1, concept 1, of course. So according to Salman, in his book Jurisprudence, law is the body of principles recognized and applied by the state in the administration of justice. In this, he has clearly told us that these are the principles which are applied by state only. Only state is the authority and he governs this for justice. Second, we have taken the definition of John Austin. Law is a command of a sovereign. That is, the state is the commander or the superior and individual is inferior and enforced by punishment or sanction. So these are the definitions which we are going to take. Of course, the last one will be of the Lord Moulton. Law is the crystallized common sense of the community. Do you know why he says crystallized of common sense? In the crystals, you can see clearly, similarly, when the law is governed in the society. You know all the rules, so you observe it. And therefore, he said that it is a crystallized common sense of the community. Now, of course, if you see the legal sense, law is a code of conduct for the people in a given community which controls their activities towards each other with respect to their private and business lives and to their relationship with the state. Very simply I have given, and you have to understand private, business. For business also you can't cheat, you can't do breach of contract, which you are going to see afterwards, and in the relation to the state you can't cheat the state also. Now we see what is the object of the law. See, everything, whatever we do should have some object, some aim. So, law was brought into the world for nothing else but to limit natural liberty of particular men in such a manner as they might not hurt but assist one another and join together against a common enemies. Otherwise, the people will not, as we have seen earlier, will not care for each other and they will just break the right of freedom. The next, according to Bentham, the object of law is the maximization of the happiness of the greatest number of the members of the community in question, because whenever there is a law and order, there is a happiness. And of course, the people know the law, they obey the law, and they know If they break the law, then they will be punished. Now, next question should be in your mind, why should we study or why should we know the law? As I have told earlier, we should know about the law because ignorance of law is not an excuse. You can't say, I'm sorry, I didn't know that this is the law. Law will not listen this. It is supposed to be understood by everyone. Now we take is the branches of law. See, the branches of law, they are different. First is civil law. Civil law is the law which is governed by all the civilians. Criminal law, who commits any crime, theft, robbery, murder, and so many. Constitutional law, which governs the Constitution of India. If anybody breaks the things which is given in the Constitution, Constitution law is observed. Then there is an international law, industrial law, and the last is mercantile law. But actually, mercantile law is not a separate branch of law, but constitutes one of the important branches of civil law only. Because all the civilians observes mercantile law. Now we go for the meaning and definition of the term of mercantile law. As this is our C2, dear. Try to understand. We have finished our concept 1. We are on the concept 2, and I am sure you all might have understood the basic of it. Now we go for the meaning and definitions of the term mercantile law. Today's word is not a very compact word. It is the world where the globalization has occurred. So we are doing all the things like trade, commerce at a global level. So in the present era of globalization and privatization, the mercantile law will have to face different challenges of newly developed situations in global villages regarding e-commerce, m-commerce, cyber commerce, etc., which were not present in previous era. Now we come to know the definition of the exact term mercantile law. Mercantile law is a branch which deals with the rights and obligations of mercantile persons arising out of mercantile transactions. You all might have known what is mercantile. From 11th we are doing mercantile means trade, business. So, it is like companies, then negotiable instruments, insurance, patents, trademarks, everything comes under mercantile law. So mercantile law, if you say in that way, it includes the industrial law also. Because industrial law is nothing but relation between employer and employee. And we saw that insurance, copyrights, patents, trademarks, everything is included. That is, even the industrial law is included in mercantile law. So please keep it in mind that mercantile law is a civil law and industrial law is included in mercantile law. Is it clear? Okay. So now we go for the next. Next is, which are the sources and scope of mercantile law, which is a C3 for us. That is the third concept. Okay. Now, first is English mercantile law. English mercantile law itself suggests it is based on English mercantile law. The Indian mercantile law is based on it. Why? As you all know, first we were under the Britishers. So definitely the first, when we started mercantile law, the Indian mercantile law was based on English mercantile law. Then it is based on English common law, principles of equity. See, that is the basic of our constitution, that equity should be maintained. Law merchant or lex mercatoria, that is maritime usages, because under those time when we were under the Britishers, the trade was basically conducted by ship, that is the voyages, ocean voyages. So law merchant was there. Then comes the statutes of the British Parliament. It is the superior law and a supremacy or other laws, because it is the statute of British Parliament itself. Last is the rules of the Roman law. Now this was the first, we talk about English mercantile law. Now we come for the second, which is judicial decisions or precedents, means whatever the cases already happened in the Supreme Court or High Court in India, its decisions are binding on all courts subordinate to it. Now the third is statutes of the Indian legislature. First we should know what is a statute. Statute means act, which is passed by the Houses of Parliament and signed by the President. Please take care of this point, that it is passed by both the Houses of Parliament and it is signed by the President, and then it becomes an act or statute. First it is known as bill. When it is passed, it is known as an act. Now important act passed during the British rule: Indian Contract Act 1872, Negotiable Instrument Act 1881, Sales of Goods Act 1930 and Indian Partnership Act 1932, Companies Act 1956, etc. Now the fourth is customs and usages. The name itself suggests that it is a Indian mercantile law. As we know what is a mercantile, mercantile means the trade. Customs or usages is ancient, reasonable and not opposed to any statutory law. Custom or usages may supersede the statute law. Always remember, it supersedes the statute law. A custom gets legal recognition when incorporated in judicial decision and accepted by court. When it is accepted by court, it is binding on all people. Now we take the last is scope of mercantile law. As we know, the name suggests is mercantile, that is a business. And each business transaction should be carried out in accordance with the provision of the law. The name of the law which I am going to tell you now are the syllabus or the chapters which you are going to study in detail in BRF. So we just take the names because this is an introduction as you understand it, and later on we are going to see it deeply. So first will be of course law of contract, because all transaction starts with the contract. Second is law of sales goods. Business means selling and purchasing. Third is the law of partnership. Fourth is the law of negotiable instruments. Fifth is law of arbitration. Sixth is law of insolvency. Seventh is law of carriage of goods. Eighth is law of insurance. Ninth is law of companies. And 10th and the last is industrial law. So, friends, this is the introduction of BRF. In the next lecture, we are going to start with the next chapter, and I'm sure you might have liked it. Thank you very much for listening to me. If you like my video, please subscribe my video. Ask your friends to subscribe it. So let them also take the advantage of this lectures. Please give likes and comments if you want something specially from us. Thank you very much. Have a good day.